Let's take a look at agency discretion. A great majority of agency actions are informal. It's the exception, not the rule, in both rulemaking and adjudication that formal procedures must be used. The Administrative Procedures Act, APA, and other laws govern both rulemaking and adjudication. Agencies also perform many functions that fall outside the rulemaking and adjudication model. These acts are governed by the rules concerning informal procedures. However, because these informal actions constitute the bulk of administrative work, they've been referred to as the lifeblood of the administrative process. In most instances, informal actions are not governed by statute. Accordingly, agencies exercise significant discretion when performing these functions. An agency has discretion when it has the authority to choose between two or more options, often with few limitations. Naturally, too much discretion can result in unjust, arbitrary decisions. However, too little discretion can result in inflexible public administration, which can be equally unjust. The challenge is to find a satisfactory middle ground. Regrettably, agencies are often given too much discretion and are not adequately checked. Exclusive and unchecked discretion can lead to arbitrary decision-making. The framers were concerned about this. That's why they protected civil rights through the federal constitution, state constitutions, and statutory law. These rights act as limits on the discretion of lawmakers and law enforcers. To be sure, Americans are suspicious, if not fearful, of discretion. Nevertheless, discretion has its benefits. Discretion is an inherent and necessary element of public administration. Discretion is needed to ensure humanity in government. In an effort to achieve fairness, we've excessively limited the discretion of public officials in some policy areas. In some cases, limiting discretion has achieved its objective. In other cases, however, controlling discretion has proven difficult. Sometimes the cure is worse than the symptom, that is, the control may have unintended consequences. There are instances in which Congress has created significant limitations on discretions, and others where it hasn't. As you can imagine, it's much easier for a court to review an allegation that an agency's not complied with a rule than it is to review an allegation that an agency has abused its discretion. In particular, agency decisions not to act are rarely successfully charged. It's when an agency acts that's most at risk of reversal or of civil liability. Often when agencies act informally, there are few or no procedures to protect individuals. Discretion may be either unfettered or hampered by only minimum constraints. Therefore, questions of fairness are common in this area, and due process is often at issue. Judicial review of discretionary decisions, however, is limited. Be aware, however, that the law, as enforced by the judiciary, is not the only limitation on agency discretion. Political accountability is also a limitation. Angering Congress, the President, or the public can have detrimental consequences for an agency. As part of the executive branch, agencies perform law enforcement functions. Generally, the Department of Justice, through its offices of U.S. attorneys, is responsible for enforcing criminal statutes even when the subject matter of a criminal prohibition falls within the jurisdiction of another agency. Agencies, however, prosecute the administrative aspects of such violations. While performing such functions, they exercise the same discretion that federal prosecutors do when enforcing criminal law. Prosecutorial discretion includes deciding whom to investigate and prosecute, whether to settle a case before, during, or after a prosecution, and related decisions. Agencies also exercise discretion to decide who should be prosecuted. As previously mentioned, agencies do not possess the resources to prosecute every discovered violator. Although the discretion as to whom to prosecute is broad, it's still limited. An agency that is delegated rulemaking authority has the discretion to promulgate what rules it finds necessary, and a party cannot claim that a better rule should have been promulgated. As a general rule, the courts are to defer to an agency's interpretation of its congressional mandate. An important function performed by many administrative agencies is the processing of claims and applications. Agencies establish practices and policies to govern the processing of these claims. Each agency has the discretion to decide its processing method. Agencies often establish testing and inspection requirements. The authority to test and inspect is extensive. Laws can be ambiguous and vague. How a statute or regulation will be applied to a particular fact may be unknown or unclear. Advisory opinions are a good tool for assuring compliance with the law. It's often easier to comply with requirements before engaging in a practice than it is to cease the practice later. A similar tool is the declaratory order. The APA provides that an agency, in its sound discretion, may issue a declaratory order to terminate a controversy or remove uncertainty. The declaratory order is an administrative equivalent of a judicial declaratory judgment. Its purpose is to resolve questions of law that have arisen but have not yet been contested. Some administrative agencies are charged with the responsibility of conducting mediation and arbitration. Mediation, also known as conciliation, is the process of intervening in a dispute with the intent of assisting the parties to reach a resolution. Arbitration is the process whereby the parties submit their respective positions and arguments to a third party for a decision. Mediators act as go-betweens and arbitrators act as decision-makers. Mediation is usually voluntary, although some statutes require it. Arbitration is also usually voluntary, although some statutes also require it. Arbitration is sometimes binding on the parties. An administrative agency that conducts mediation is the Federal Mediation and Conciliation Service. The service acts as a mediator in labor disputes that affect interstate commerce. It also has no authority to compel arbitration, but its enabling statute allows it to conduct arbitrations upon agreement of the parties.